Why?
They're written on that one sign.
No, I'm going to give it to Lee. Why are you up here? Here.
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Defendant.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which
From the moment this man opened his mouth, the courtroom shifted into chaos. He's not just any defendant. He claims to be a natural person, a living man under common law, and insists the court has no jurisdiction over him. Sounds bizarre? That's because it is. In this explosive courtroom showdown, we're witnessing the collision between legal reality and sovereign citizen fantasy. The judge is calm. At first, but the tension builds. The patience wears thin. And what happens next? Let's just say if you thought yelling "I object" was enough to stop a trial, you're in for a wild ride.
4001A3, a bankruptcy rule.
Right.
Creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th.
There it is, the sovereign citizen's opening move. I do not consent. As if the justice system is an optional membership club. But courts don't operate on permission. They operate on law. And while the judge tries to keep things orderly, this man's refusal to acknowledge reality puts the entire proceeding in jeopardy. The courtroom is shifting from procedure to performance.
Until such time as the appellate court does something. Additionally, Your Honor.
Oh, yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect.
He invokes common law like it's a magic shield, protecting him from all consequences. What he doesn't realize or refuses to accept is that these arguments have no legal standing. This isn't a YouTube live stream or a Facebook comment section. This is a courtroom, and the law here is real.
Present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor.
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous.
Now watch closely. This is where the judge draws the line. Calm, clear, and nonsense. Sovereign arguments meet judicial authority, and it's not even a contest. This isn't just a power struggle, it's a reality check. The defendant came to play legal fantasy. But the judge came with a rule of law.
Because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction, so I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay,
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
And yet, he keeps going, repeating the same discredited lines like they're part of a script because they are. From online message boards and pseudo-legal manuals, sovereign citizens rehearse these exact phrases, thinking they've cracked the legal code, but in real court, they're just digging a deeper hole.
Least with, allegedly, with Miss Whitlow,
Correct.
then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know.
communicating with
I don't know
Max.
that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did, the,
They are not here. I don't know. I have documents that are not, that they filed with this.
You can feel it now, the shift. The judge warns him about contempt, and that's serious. This isn't a game anymore. And someone refuses to follow courtroom rules, the court must act. And contempt can mean jail, fines, and a permanent stain on your case. But the defendant is too far gone.
Can and as of right ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract,
Mhm.
but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental.
It ends not with clarity, but confusion. Papers flying, terms misused, a defendant utterly detached from the real world. And yet this isn't rare. Sovereign citizens are showing up in courtrooms across the country, weaponizing legal ignorance in hopes of escape. But as we saw here, it only leads to more trouble.
Contain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to obtain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to obtain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount.
If you thought that was wild, just wait. We have more courtroom chaos, legal drama, and real consequences coming your way. Hit that subscribe button, turn on notifications, and let us know in the comments. Should courts start cracking down? Harder on sovereign citizen antics? Till next time, remember in court, facts beat fantasy every time.